So now let's go back to the third round of questions. Dr. Chen, third round, 5 minutes. Take your time. Thank you, Chairman. Okay, back to this paper. CB 21521718-01 is about the patients' rights and patients' groups and the elections by the groups. And so it's nothing to do with the patients' groups, but the patients' groups election regulations. So I hope that the administration can give us some timetable and information, as in the case of the academy, where would you have negative vetting and come up with the subsidiary legislation for our reference, so we can know about your work ahead. And for patients' groups themselves, patients' groups, after the this bill takes effect, and the patients' groups will create members for the council. So back to the functions of the medical council, which include registering Hong Kong doctors, medical practitioners, and carry out regulatory matters. So there could be applications that will involve applications for renewal of license, which require the approval of 13 members, including lay members. In the future, there will be patients group representatives being among those members. So lately, there was a court ruling in which, for example, in the jury, when the jury members have some open intention, then the prosecutor would say that, well, in a recent case, indeed, the court has some opinions on that, on the open stance of jury. So patients groups supposed to defend patients' rights, but some members may openly express their views on certain doctors, personal stance or feelings about doctors, some doctors. So, and doctors, in case of a hearing, could be denied the chance to renew their license or have their medical license restored. So, would there be any chance for judicial review in the case of a jury member who, in the start, openly expressed their feelings against the doctor concerned? Would that affect would the stance of the jury members affect the outcome of the court ruling? Human rights groups. And, there is actually precedence of human rights groups, of being actually involved in judicial review because of their stance against certain parties in a court case. In a UK case, in fact, there are precedents. The case is about the extradition of a Spanish politician back to UK, and during the process of trying to get the Spanish official back to UK is because of a judicial review and by a human rights groups, and finally the case had to bow to the pressure. Well, as for the timetable for the subsidiary legislation on patients groups, having discussed with GFJ, we will submit the subsidiary legislation ASAP after the amendment bill is passed, because the patients group needs to conduct the elections, right? And secondly, as for your worry about whether there could be conflicts of interest if a patients group has expressed views on particular case, then in the existing legislation, there is a mechanism for declaration of interest already. That is involvement in the preliminary hearing, members participating in those, PICs, they will need to declare the interest. And then the chairman and vice chairman of the PIC would decide whether the member concerned is fit to remain on the investigation committee. So in the amendment bill, we found what's lacking now is during the investigation, there's no statutory requirement for declaration of interest, even though the declaration is practiced. So we would now include the statutory requirement in the law. That is in the amendment bill. I think that would address your concern about possible conflict of interest. Thank you, Chairman. Dr. Chen? Okay, just then you said the subsidiary legislation will be put forward after the passage of the Medical Registration Amendment Bill 2017, but haven't heard the concerns made by other members just then. We hope that when scrutinizing this amendment bill, we hope that we can actually look at the provisions for the patients' groups and not after the bill is passed. So can you let us have a look at the wordings beforehand, before the bill is passed? It's not about declaration of interest. It's nothing to do with interest. It's nothing to do with interest, but about, of course, every time a hearing takes place, there will be the prosecuting side, the defendants. It's not about interest. The declaration, well, because of a limited number of doctors, just about 13,000. So in the case of a hearing, the parties will need to declare whether they know the doctor concerned, or whether they're in close contact, or whether they knew each other, or they worked together before, or collaborated in writing academic journals, literature, and so forth. If the answer is yes, then the members concerned will need to leave the investigation committee, because that could undermine the process and outcome of the investigation, leading to judicial review. So it's not about interest alone. It's about, like in the recent court case, a court ruling, the jury of a court. Okay, jury members have to be downsized from 9 to 8. And also, like in UK case, that's what I'm referring to. It's about the stance of preconceived stance of a jury member that could affect the chance of appeal and also the process of investigation or the court hearing. So maybe Mr. Fong, you could say a bit more. We don't want to see the wordings till after the bill is passed. As I said in our background brief, Annex D, it has laid out the framework for the election by the patients groups. So as for the details, the legal writings, well, actually, we discussed them before, actually, in the Bills Committee. So I think that, but of course, I'm sure members will have time to look at the details of the subsidiary legislation in the future. And also, as for conflict of interest, right now, before the hearing, the lawyers concerned could actually see whether members have any conflicts of interest. So there's a mechanism now, and the current mechanism can deal with the concern expressed by the member just then. When we did the amendment bill, we did look at the UK case you mentioned, and in this amendment bill, we have added the provision that members of the PIC need to declare their interest beforehand, and if a member is found to be unfit for remaining on the PIC, he would need to excuse himself, and we need to set up a new committee to do the work as a result. So I think to a certain extent, we have addressed your concern. I don't quite get what you said. I understand what Mr. Fong just said, but to ask a bit more. Say, if I were a member of a hearing, say among the statutory 5 members, if my experience is that, say, only on the day of the hearing did I know who the defendant was, maybe 1 or 2 days, a very short period before the hearing, the day of the hearing, would I know who the defendant was? And if I only declared then, so the time frame is very short, as a doctor member. So my question is, for the defendant, the doctor concerned or the lawyer, if they had known long ago who would be on the hearing on the PIC, then would they have known about it earlier? Okay, Mr. Fong. Okay, if necessary, I will ask the secretary to supplement. There are 2 stages. A week before the hearing, the members would have to read the papers, right? So a week beforehand, they will receive the papers and know about the case. So a week before the hearing takes place, if the member thought that there would be conflict of interest, then he should declare, and so that he might not be fit. He might not be fit to be a member. And then the council's secretariat will need to find a replacement. That's stage 1. And stage 2 is on the day of the hearing, if all of a sudden it's found that there are interests, newly discovered interests, then members will need to declare them. And the lawyers on both sides could raise the concern that a particular member may not be fit to remain, to ensure that the conflicts of interest would be minimized. Any supplement from the secretary? Mr. Seal or Ms. Lai? I think Mr. Fong has just mentioned the current arrangement. In terms of conflicts of interest, I think the current mechanism has addressed that. And with the change in law in the future, at the time of the PIC hearing, we will make it clear and strengthen the reminder that declarations of interests are needed.
So the defense or the defendant doctor will know a week before, and can they do anything to say to state their stance? Say, for example, the suitability of candidates of panel of members. We give them 10 days. And if there are objections raised by the defendant doctor or the defense, then a decision will be made as to whether another member will be appointed. Dr. Kokaki, 3rd round. I want to ask about Annex 2 Fellows of the Hong Kong AM. It's Cap 419 Section 2. You find definition of Fellows of the Hong Kong AM. So unless there is a change in the law, the Hong Kong AM will not change the definition of fellows. Is that right? Or is it the case that the Hong Kong AM has the discretion to change the definition? There are membership apart from fellowship, because they are not fellows yet, but they are going to be, and there is a chance that they will participate in an election. So far, the Hong Kong AM has not made a decision. In the future, if the Hong Kong AM makes a decision to allow members to participate in an election, does the administration need to amend the law to expand the eligibility to participate in an election by expanding it to members? Well, the Hong Kong AM ordinance has already defined fellow. Fellows are those that are mentioned in 3 bracket 3A1, and it doesn't include those who are not yet fellows, namely members. If the member wants to include those who are not yet fellows, then indeed we need legislative amendment. So there are 2 ways to do it. First is to change the Hong Kong AM Ordinance Cap 419 without changing Cap 419. If they want to extend the voter eligibility to members, can they do it through medical registration ordinance? Well, I will ask the DOJ to reply whether it is feasible on the point of law. The spirit of our amendment states clearly that they are fellows of the Hong Kong AM. And as to whether it's done through 419 or 161, I will defer to the DOJ. Ms. Chuck. Thank you. As the Bureau explained, we use Cap 419 as the basis. If you want to change the definition of fellow, in theory, we can give a definition of fellow under Cap 161. But that is not ideal, because fellow is a kind of member of the Hong Kong AM under Cap 419. If we give it a different definition in a different piece of legislation, well, if you're from the medical sector, you know what a fellow is. You get an idea. So it's not ideal to deal with it with Cap 161. But if we want to adjust the definition of fellow, changing it in 419 will be more appropriate. And 161 is packed with 419. Our approach is to pack 161 with 419. So if it's changed in Cap 419, it will change in Cap 161. I was talking about voter eligibility, not the eligibility to be a fellow. Of course, it is for the Hong Kong AM to decide. Currently, there are 7,000 fellows, and if you count members, that will be close to 10,000. So it will be more representative. It will be more in line with our original intent. I don't rule out the possibility that the Hong Kong AM may amend that. I agree that the eligibility of a fellow cannot be changed. But what about voter eligibility? Can it be done using Cap 161 to include members of the Hong Kong AM? It's just about voter eligibility or nomination eligibility. Ms. Chuck, let me try to understand members' point. In 3(2)HA, you see that it says that well, nomination and election are done by fellows. If there are views that in the future the election may not just be fellows, other members of the Hong Kong AM may participate, then we will do it. We may do it under 3(2)HA, because the definition of fellow is very restrictive. If you want to expand it, then you need to consider whether to use the word fellows. So it's just to add members, fellows and members. It won't be difficult to amend Cap 161, right, Ms. Chuck? That is also a policy matter. If the government accepts this approach, then they will have to define member. Under Cap 419, the word member, well, we will have to look into it to see how we can describe it, because there are different types of members. Ordinary fellows, they are all members of the Hong Kong AM. My understanding is that they're talking about subsection 3A Roman 2, just ordinary members. So we'll have to see how it can be worded. I ask because I may propose CSAs to expand that. So we don't have to touch 419 if we just expand it to members of Hong Kong AM from just fellows. Ms. Chuck, she said that will be all right. That can be done. Legal advisor, I understand Dr. Kwok's question. Yes, it can be done in Cap 161. But if it's by CSA, then the chairman will have to make a ruling whether it's relevant and whether there is any charging effect. The second question is about patient organizations. Currently, lay members don't come from a particular background. In the future, that will be changed. Well, it won't be for the HA, SWD or the Society of Rehabilitation to decide. They only coordinate elections. There may be more and more doctors in the public sector having to undergo disciplinary hearings. The hearing result may have an impact on policy. There are two parts, personal liability and the organization's liability. In the past, there were no lay members from patient organizations. Currently, if it involves a public hospital, or if the doctor in the hearing is from a teaching hospital, say Queen Mary or Prince of Wales, so it involves the Hong Kong U or the CUHK, will they decide on their own initiatives for their own members to excuse themselves? Has there been any such occasions? In the future, when there are members from patient organizations, is there a greater need for the Hong Kong AM to set out guidelines stating clearly about conflict of interest, so that anyone involved in a disciplinary hearing will be treated fairly and they will not be sacrificed because for the protection of interest of a particular organization? Let's hear from Ms. Chuck. No, sorry, Mr. Steele. When we invite members to become members in a in a panel of a disciplinary hearing, well, we don't impose any restrictions. However, if the member itself is a doctor in the public sector, and if the doctor in the hearing is someone they know, then yes, that person will not be suitable to sit in the panel, and we will choose another member to take their place. Well, yes, if that person knows the defendant doctor, I understand, but it's not about that, it's about the capacity. Say, for example, defendant doctors or any person involved, there is another capacity. They are members of an organization. Say, for example, it's staff of the Department of Health, and the member representing the employer, i.e. the Department of Health, is there. So apart from personal liability, there is organization liability as well. Say it's me. I'm not talking about the hospital authority, just any situation. I am an employer. There's no reason for me to admit liability. If it's a really fair person, then the person would say that, well, hospital authority is wrong, but the doctor is not liable. Or the other way around, the doctor should be held completely liable and the organization is not. So are there any mechanisms to deal with situations like that? If it involves doctors from the hospital authority, from universities, or from Department of Health, are there any mechanisms to deal with declaration of interest and for a member to withdraw? If not, why not?
Mr. Seal? According to my understanding, there's no mechanism to deal with the issue raised by Dr. Kwok. Well, in that case, I'm worried, Chairman, because, what I said would definitely happen. Mr. Fong, you can see that more and more members, if they're elected, they have their own capacity, but if they're members of different organizations, then they are obliged, whether it's the government or medical council, but I know council is an independent organization, but they are obliged to make sure that the hearing would not put the defendant doctor in a disadvantageous position. So you need to have a good system to ensure that. So either the medical council or the government ensure such a mechanism exists. If there's no such mechanism, I'm worried. I think it's difficult for him to answer you. So can you now, with the new amendment bill coming up, you need to provide clear provisions to ensure that the future hearings are fair and just. Thank you. Dr. Kwok raised a very good question. And in this amendment bill, we have increased the number of assessors, and they'll be nominated and appointed by the council. Your question was good, but I will pass your concern and view to the medical council. So when they recruit a large number of assessors, we will see whether they need to review the code for declaration of conflicts of interest. We relate your concern to the council. Okay, my suggestion here. If you all agree, and if Mr. Fong agrees, or the two colleagues from the council agree, please relay this view to the council as soon as possible. And can you make sure that after the meeting we can be given their response? That is to have clear provisions to make sure that there are clear guidelines for members involved in the hearing and to ensure that the defendant doctors in the future are treated fairly and justly. You can give me the information next time. Dr. Chen, the fourth round. Just then, giving information to Dr. Kwok and Chairman. Fellows. When it comes to fellows, paper 152 17/18/01. Okay, and just give you some background information. For fellows within the academy, there's an exceptional case. Look at Cap 419. Under Cap 419, it covers a definition of fellow. That is, fellow is based on Section 331A and 33A1. Talks about the conditions for fellows. They are namely people who have finished obtaining the credits and passed the required examinations and so forth. Most of the fellows are specialist doctors. I think more than 90% of them are specialist doctors. Well, you pass through 6 years of medical education, 1 year of postgraduate training, and 1 year of housemanship and so forth, and then training within the HA, and then you take the interim examination 3 years later, and then 3 years later you take the specialist examination. Many of them became a specialist in their 30s, and then they applied to be a fellow. That's what applies to 90% of the doctors. So I mentioned the interim examination, but in some colleges they call those who pass exam a member. Some other colleges call them associate member. So just to remind you, there's a family medicine college. After its interim examination, examination is done, the college would define the person who's passed the exam as a fellow. So under the law, there will be a small number of doctors who are not yet specialists and yet classified by some specialist doctors as fellows. I do agree with what Dr. Kwok said, but I'm just telling Dr. Kwok what can happen now under the current system. So it's not just fellow. Fellows do not just come. It's not a term used exclusively for specialist doctors, because we need to consider the chain effect or domino effect. With the current classification system. And back to the government's amendment 2152070805, government paper, section 3 of the law. GP is a lay member nominated by the Consumer Council. So my proposal on this is that it should be a lay member nominated by the Consumer Council and appointed by the Chief Executive. Why would I make this proposal? It's because nomination by the Consumer Council, if that's it, with no words following that, then the term of appointment would not be limited. And also, as I just said, whether what role should members play, I think that on the whole, from an administrative perspective, we don't need to talk more about the appointment of patients' organizations representatives. But if the lay member concerned is appointed by the Chief Executive, the whole thing would be simplified, whether in terms of the term of appointment or whether he is to withdraw later and so forth, or he's holding office. The whole process will be simplified. Ms. Liu? Ms. Lau, for member nominated by the Consumer Council, whether in terms of vacancy or length of appointment, even for temporary members, we have made amendments to ensure that these members are bound by the same arrangements applicable to other members. The current provisions already has addressed your concern, indeed. Dr. Chen, what do you think? Understood? Well, no other questions then. No other members have questions? If so, then we would end up discussion on this paper, CP2 152/17-18/01, and we'll discuss the other English papers on the amendments by the administration next time. I've asked the secretary to write to ask the 30-odd organizations whether they would like to come for a public hearing. Of course, the Doctors Union? Well, we don't need to ask the Hong Kong Doctors Union. If the organizations are coming, we'll do it on the 27th. If there are few organizations, then we can have the hearing and then continue with our scrutiny on the same day. So thank you all. No AOB. Meeting adjourned.